because in the Court of Appeal, we were made to understand about 20% of the justices of the work justices of the Court of Appeal will be off before the end of this year. Already about 18 justices of the Court of Appeal have retired. Vacancies existed. And now they appointed 9, but they're in the process of appointing more justices of the Court of Appeal and dissenting justices of the Supreme Court. Because the workload on the justices of the Supreme Court is something else. The people have courage and they need to appoint more justices to that court. And I think the government is taking proactive steps to address the situation.
And we're hoping that it actually gets moved very soon, that those 8 or additional judges are appointed in order to help with the caseload. But there's some that recommend amendment to the Constitution concerning making them increase the number of justices currently serving to 30 plus. Do you think that this is another avenue that could be explored?
Well, that is part of it, but I think the most important thing is to allow certain matters not to reach the Supreme Court. It's matters of constitutional matters, matters of serious concern, which involves very serious legal issues, issues of law that ought to go to the Supreme Court. But now you see, even ordinary land matters that sometimes start from area courts ends up to the Supreme Court. So we need to have certain interlocutory applications up to stop at the Court of Appeal. So this need on ordinary issues of stay or execution sometimes drags on to the Supreme Court. So there must be some way to structure the Supreme Court in such a way that real legal issues goes to the Supreme Court. Now, of course, there should be areas we can touch to ensure that really the Supreme Court is not overburdened on frivolous matters. I think we also have, on the side of the lawyers themselves, we lawyers, not every appeal we should aim to go to the Supreme Court. Some are really not worth going to the Supreme Court. We should try to look at alternative dispute resolutions. Some matters can be settled that way without reaching the Supreme Court. I think it's not really the number of judges. If we increase the number of judges, but cases continue to go to the Supreme Court at the rate at which it's going. You know, there's so much awareness and litigation now. Before a person goes by the time he reaches the High Court, he's tired. He say no. But now, everybody who started litigation, he will boasting that I'm pursuing the matter until he reaches the Supreme Court. So that's the dilemma. Even if we increase the number to 36, but still, if we don't control the number of cases that go to Supreme Court, we're still going to have the same problem. So my concern is to look at the Constitution. Other issues can go to Supreme Court, but only leave for the Supreme Court. That would be very desirable. And leave can be heard by a single justice of the Supreme Court, or to grant leave or not. That will be, we look at those areas, and that will be much better.
Well, what about political cases? The Chief Justice of Nigeria, Justice Kayode Ariwoola, believes the bench is overlabored and political cases are taking a monumental toll on them. So would having maybe a special court set up for election disputes help resolve this matter? Or do you think it's something that can also be handled at the level of the appeal court?
Political awareness is going, but at a point in time, people will also try to accept decisions by not going to court. It's not a matter of establishing cases, not a matter of establishing more special courts. It will still end up. Those special courts may not, you not create a particular court and say it doesn't have an appeal, an appellate, his decision cannot be appealed again to a higher court. That will create anarchy. So even if you create a special court, you will expect the special court appeals to go to Court of Appeal and to Supreme Court. Because the special court cannot just be created and make it a court that cannot be appealable. So this is the problem. The problem may not necessarily mean special courts, but looking at the way we should learn to accept some defeats, where you know that the electoral process was substantially in compliance, but the system will evolve itself in a better way. I'm very optimistic that the system will grow, electoral culture is still growing, it will grow, and then the people may not be going to court much, and then things will be much better. It's not a matter of establishing more court power.
Would it be more of a matter of establishing jurisdiction over what kind of cases the Supreme Court adjudicates? And also, what do you think about the retirement age? Maybe raising that a little bit just so that some of the serving members of the court could have a little more time. What's your opinion?
Retirement judges should be raised again, or the Supreme Court justices should be raised again. I think it came out when I was Attorney General, but we looked at our system. In fact, it first came up when I was Attorney General that the justices of the Supreme Court should retire at the age of 80. We felt it's okay, but we looked at the head system. We looked at the manual manner in which they conduct the businesses of the court in Nigeria. And we felt that it's more desirable for them to retire at 70 and still have some few useful age to attend to their family. We did not include that in the amendment of the Constitution. And I think even now, if you look at it from that perspective, if we have modernized our court, we're not doing handwriting, and we're not doing all these things, you can also say, okay, they can stay out to 80 years. But they are doing manual writing, and it's very tedious for you to have moved from High Court, Court of Appeal to Supreme Court doing manual writing to expect you to live out to 80 years. I think it may not be, but I don't know how they feel about it. But to me, when I was a General General, I felt it was not proper. I also look at the mortality, the rate, the date, and I felt that if you say people should retire 80, how would the younger ones ever reach the Supreme Court? But that was my own perception as Attorney General at that time. I felt that as they 70 years, there should be space for the others to also grow and reach the Supreme Court. That was my desire. And up to now, I don't think I've changed my position that the retirement age should still remain at 70, except life expectancy has moved up in Nigeria and medical facilities have moved out, and then we have totally embraced ICT in our technology in court proceeding. Then we can think about that. But for now, I think it will not be hard for them, for the learned justices of the Supreme Court, to aspire to go to 80 years.
Now, in